Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, please hit that like, share, and subscribe button. There's a PayPal link down below for anybody who wants to share some love. All is appreciated. And right now, I'm just going to do a monologue for a bit, and I might open the panel when I'm done. We'll see how it goes. And as you know, we're talking about the First Amendment tonight. Specifically, the petition, the right to petition the government for a redress of grievances. And it seems the authoritative body in all of this doesn't want to take responsibility for the second part of that right to petition the government for redress of grievances, sustaining that there is a substantive obligation in that petition. And so I'm going to start out tonight with a jester. What is a jester? And I'm going to put the First Amendment up here for you, for everybody, so everybody gets the First Amendment and its 5 points. And before we get into the jester thing, I want everybody to know my view is my freedom of speech is my ability to express myself to an assembly of people other than myself and another religion other than a religion I may or may not have followed in the past or may not follow in the future. It's the people, no matter what their spiritual background. And then a petition. Now, the petition is relative to the king that the people want and so much desire to lead them. And this is the first inherent problem in people wanting to assert their rights without understanding you have an obligation in enforcing that right. So when I say I have the freedom of speech singularly, that's a great right expressed in the First Amendment. In that freedom of expression is a greater right because the people that I'm expressing it to and speaking to collectively in a greater number than my singularity means that their right is exponentially greater in that aspect. In that, the king that the people choose to have as their leader and all of his minions, they too, in making that declaration, making that constitution, and declaring that the people have the right to petition them for a redress of grievances, is not just a matter of accepting of that obligation as a king, but also the recognition of the separation of powers. The separation of powers that when the people become so despotic because that government is not listening and enforcing that very protection, that's why the people rise up in revolutions. That's why we had the original American Revolution and then the Civil War. So let's get on to that jester. And the reason I want to bring up the jester is a comparative to the guy sitting on the bench in that clown suit. See, he's truly the jester. And a jester is a diplomatic tool. It is a matter of diplomacy, wherein a jester's main purpose in the king's court was to entertain, but not just with jokes and tricks. Their role was multi-layered, and the humor was just a funny distraction because their main purpose was to ease political tensions and emotional heaviness. They effectually help lift spirits and diffuse tension, whereas the clowns in the robes, or the people in those clown suits, those black robes, they don't lift spirits. They stomp on them and infuse tension. But they do the same thing. They use their politically intense situations and their emotional heaviness to stomp on people for control. And that's not for entertainment and morale, it's for control and reduction of morale. Plato's cave. So the jesters in the old times were basically people that told the truth in a humorous way, but they were the only people that were allowed to do so. They made humor of the king, the policies, the noblemen, all kinds of stuff. And he's basically an advisor in disguise to the king, because he was able, through laughter, to reveal the deeper insights. In these courts, these jesters are revealing the deeper insights of the fear of mankind. Paying tribute to that false patriarch, believing that your identity stems from that. You violate your own religion. And then instead of petitioning the government for a redress of grievance, you think this right to peaceably assemble means you can go out and have demonstrations that are violent. I don't think you understand. And so when it came to the jesters, like I said, making fun of the king and the noblemen and all the people and everything, he was the central focus of the humor, so that one man saying it to another man didn't take it in a disgruntled manner and end up with a civil infraction for fighting or causing chaos or, heaven forbid, killing one another. You know, that's how they ended up in situations and duels and stuff. So the jester played an intermediate role to relieve that kind of stuff. The people we see on these benches are playing the same intermediate role, but they're doing it to escalate. Follow the money. Who do you think's making money on all this stuff? Who do you think they're giving it to, dispersing it to? You think they're giving it to friends or family? They're certainly not giving it to people they're pulling up in the courts. Those are the ones they're taking it from, in violation of both the 4th, 5th, and excuse me, in all the 4th, 5th, and 10th and 14th, 9th, 10th, and 14th Amendments, as well as the First Amendment, by not listening. There is a clear separation of power. And the jester was able to hold up the mirror to power without being overtly confrontational. He was the diplomatic balance. Did you get a high school diploma? You're supposed to be diplomatic, but that's the problem with the public education indoctrination system. And I understand that. I too was indoctrinated. I too was a bitch-ass slave. I too was a fool. So technically, the jester was used as kind of like a safety valve. But now we've got a population of people that believe that the king has, and its government arms have so much power that they are subservient. They forget they're the real kings. The government only gets its power by consent of the people. So when we're talking again about that right to petition the government for redress of grievances, they've been denying it for a long time in many venues, all the way up and down the line. This is what we've got to get over. And we've got to use this jester type stuff in these courts for insight and perspective, so we can become that strategic player. We have to educate ourselves. My people are destroyed for lack of knowledge. And so as it relates to the First Amendment, that guarantee of the right to petition the government for redress of grievances, it's a protection, but it doesn't spell out the specific process. And it leaves the process, the proper process dependent upon the level of government, the issue, and what kind of redress you're seeking. And a lot of people think they need to go to these administrative courts to seek that redress, or they need to go to the mayor to seek that redress, or they need to go to this guy or that guy. And I've been saying for a long time, it's the First Amendment clearly states that you have the freedom to express yourself singularly, like I said. But exponentially, the power of that right extends into the people that you're telling it to, and that should help embolden you to speak out. And learn that when you speak out, it should be the shot heard around the world. You should speak out so the world hears it. Coin your words or purse your lips. And it's the core right. Again, we came to wars because the government didn't want to recognize this right. The right to petition the government for redress of grievance before the people bear their arms and throw off that despotic government in terrible, heinous acts of killing each other because it becomes so bad. And while it gives you the right to ask the government to fix a wrong, injustice, or harm, they seem not to believe that it doesn't guarantee that the government has to respond or act on your petition. And that's the egregious part. Because, see, these people are taking upon this job in good faith and fair dealings. According to their oaths under God and stuff, they're supposed to have that moral and ethical code to do unto others as you would have them do unto you. Basic. So if you have a problem with the school or the zoning board or the police departments or city council, that's at your local level. Or if it's your administrative agencies or the legislators or governors, that's at the state level. But if it's with the president, federal agencies, or Congress, and the courts, the actual courts, that would be your federal system. They each have their own procedures. Some have public comments or testimony. Others have written petitions or letters. That's what we're talking about here in the First Amendment, petition. And that's the government. And the only one mentioned there was the local agencies and stuff of government, but the government that we're talking about is federal. Otherwise, they're administrative complaints and simple court filings or records requests, things like that. You're not really communicating with the president and Congress and structuring an agreement of equal station. The right to hold the same powers, that separation of powers that we're talking about, that's the right to administrate your own affairs. Plenipotentiary. And so in the petition, it's merely a writing making a clear statement of your grievance. You know, what happened, who did it, and this and that, why it's wrong, unjust, illegal, and what kind of redress you're seeking. You know, is the record going to show that you're owed and due monies of some sort, whether they be a mere extension of credit, or is there going to be some kind of policy change required? Do you need further education and training as far as these public officials and things like that. And you got to have evidence. You got to be willing to testify, of course. And this is why I say, don't believe me, don't believe the neighbor, don't believe the government, and for crying out loud, don't believe your mother. You have to learn to do your research so you know, so you can present yourself. As long as we continue presenting ourselves through another person, we remain in that bondage of not knowing our own identity. And of course, brings to the final point of all of this is the diplomacy in it again. So we have to take hold of the insights and perspectives like a jester ourselves. But instead of acting like a jester, we remain respectful in our tone. And this is why on this internet, on these panels and stuff, a lot of you guys will get me caught up in passion at times, and I'll get loud, I'll get rude, I'll get abrasive, I'll start slinging those ad hominems. If that's the game you want to play, yeah, I'll play them on here. But when it's on paper, you leave all that shit out, and you learn how to speak to the people you're presenting the papers to in a diplomatic tone, and let it be that without any emotions, and just let them know you're standing your ground and you're not going to budge. And you have that stoicism and sternness. See, that's the true king. The one that knows himself and knows how to stand his square. And that's on the truth. Knowing that what's been put to you before is all a presumption. And this is why I say people going out in that right to peacefully assemble, but in that peaceful assemblance, all of a sudden violence occurs. Now, is that a peaceful assembly? Nope, not anymore. Not anymore. Doesn't matter your intent. It turned into a violent assembly. You do not have the right to do that. If you have the right to do so, then you have the obligation, the substantive obligation to ensure that it is peaceful yourself, and that means you can't allow the violence. You have to police yourself. That's what policing is about, folks. It's about looking in that mirror and understanding who you are. And there's no real guarantee of remedy, even if they do listen. Again, this comes to your ability to make that remedy. Speak with Congress, present your bill. I'm just a bill on Capitol Hill. Remember that? Schoolhouse Rock. They're telling you how to address yourself by a proper redress because the trade dress was made wrong. Ever hear that term, guys? Trade dress? See, that was the address. Courts have repeatedly said the First Amendment doesn't require the government to listen, agree, or act, but it must allow the process. For example, if you file a property tax appeal with your county or state, you have to write your local representatives, submit a complaint or petition to the county commission or state tax board to pursue litigation if administrative remedies fail. Guess what, folks? The administrative remedies always fail because they're never in your favor. Even when you win, that 5% of cases that win, even then, it's still a tax to the people that have to go through this mental bullshit. Excuse my language. Anyway, we continue on because in that, I'm saying if the First Amendment protects the right to petition the government for a redress of grievances, then logically, that must include some obligation on the government to act. It has to. It has to have substantive obligation. not just allow you to complain into the void. Otherwise, it's hollow and deceitful. There's no substance to it. That should hit at the core of everyone's heart. Because these officials, these public government officials, administrators, agents that are just not listening, that's what makes it seem like it's not the First Amendment that's deceitful and hollow, but the protection of it is. And that's showing in the people. They're the ones that are hollow and deceitful. And I know it's a strong and principled view, but it's rooted in natural rights theory and original democratic intent. Think about that. That's the original democratic intent, was action. And I'm not posing to be Democrat or Republican. Like I said, I don't have any specific political agenda. I have political views from what I've seen over history, and I express them. So on this, there's two levels. It's what the courts have said, which is legal precedent, and my specific point, which is reason and justice demand. Again, otherwise there's no substance to the statement, the right to petition the government for redress of grievances. That does most certainly in the language imply by reason and logic that there is a substantive obligation to actually act on it. Unfortunately, and this is according to the judicial view, U.S. courts have consistently ruled the First Amendment guarantees your right to petition, but not a guaranteed response or remedy. And this is in Minnesota Board for Community Colleges versus Knight, 1984. I'm going to drop that in chat for everybody. There will be a couple of them. You can go look these up. And it says nothing in the First Amendment, quote, nothing in the First Amendment or in this court's case law interpreting it suggests that the rights to speak, associate, and petition require government policymakers to listen or respond to individuals' communications on public issues. And this is where we have to understand that, like the jester, they're using language. They use a different language. But even though it's common English here, many people will miss this. It says to listen or respond to individuals' communications on public issues. Now, the First Amendment freedom of speech is a substantive right of privacy, as if you can speak, you may also remain silent, as enforced in the Fifth Amendment, not to speak against yourself, to incriminate, to protect your privacy. They're intertwined. So this court's interpretation is correct when it comes to public issues. When it's a petition to require government policymakers to listen or respond to individuals, which would be employees. Those identified individuals, already identified. Those state IDs and driver's license and such. Similarly, in Smith versus Arkansas State Highway Employees, 1979, they held, and quote, the public employee. Confirming that grammar is what they're intending. The public employee may not be punished for the exercise of First Amendment rights, but the Constitution does not require government to listen, to respond, or to grant the petitioned relief. Why not? Because if he's a public employee, then he's under contract and he has to learn how to amend the contract. But when it comes to the people, the private people, that public service for which they are in contract in is a public trust. The people are the principals. They are the trustees. So legally speaking, you're guaranteed the right to ask, but not to receive a response or relief. But lawfully, on the private side, equity, which is where reason and morality come from. And this is a democratic theory again. And it says if a government offers a protected channel to redress injustice, and if that redress is never granted, or worse, ignored entirely, then the right to petition becomes a theatrical performance, not a meaningful safeguard. It becomes a facade to democracy, where the illusion of access makes actual exclusion, or masks actual exclusion. And I don't think that's in harmony with what the framers likely intended, nor with natural law traditions that say a right must be effective, not just procedural. And see, this is the importance of learning about your natural rights and all of it. Law of nations, otherwise known as the laws of nature. And think about the Declaration of Independence. Quote, in every stage of these oppressions, I mentioned this earlier, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. That wasn't just a complaint, that was an indictment, because it was the failure to respond to the petitions that triggered the revolution, like I said earlier. And it's only because of the new modern constitutional law that they claim, especially post-New Deal, they separate the process rights from the substantive obligations. Why do you think they do that? They do that so they can stick you in those local jurisdictions for the ordinance codes and lease codes and this and that, by writing a certain type of complaint, administrative complaint, or a certain type of petition or filing or record. You know, it's all the twists in the language. First Amendment says you can speak, assemble, and petition, but it doesn't force action from the government. That's what they think. That's what they're posing in these court decisions, where they're implying everything is public. Nobody's making clear distinctions as to the differences of the public employee and the public services and the private substantive rights, substantive private rights of all men. And to use some legal privilege to subvert those substantive rights by negating substantive obligations to protect them is in and of itself treason. In my opinion, of course. It's the total lack of moral and ethics in people that are supposed to have it at the highest levels. Entrusted to take care of people that were deemed incompetent and needed government oversight. Is that 99% of the population as the 1% rules? And how is this delegation of power going down through the ranks? Are we becoming Hitler's willing executioners? Courts have narrowly interpreted petition as a liberty, not a guarantee of remedy. Absolutely. It's a liberty, not a right. That's why it holds the substantive obligation. And I'm arguing for a return to the original moral purpose of the right. See, the redress isn't just a request, it's a demand that justice be seen and done. As a matter of liberty. So the current doctrine says you have the right to ask, but you don't receive. So why even ask then? Again, it leaves it hollow, empty, not worth a damn. Where is it going to get the value of the First Amendment unless the people learn this? A right to petition without redress is an empty promise. Reason and logic says real protection requires the action. And I think I'm correct in insisting that the protection implies meaningful effect, not just some ceremonial access. See, Minnesota Board for Community Colleges versus Knight focused on public policy discourse, not private grievances. That First Amendment, particularly the right to petition for redress of grievances, was originally centered around personal or private injustice. The philosophical and legal core of the First Amendment's petition clause to begin with. In the Knight case in 1984, the case was about public employees objecting to being left out of certain policy-making discussions between their employee, a state agency, and an exclusive bargaining representative. And the court said, quote, "The First Amendment does not impose any affirmative obligation on the government to listen, to respond, or to recognize an association. Congress shall make no law respecting the establishment of a religion." Again, why? Because it's literally a liberty, a substantive right. You can't just tell somebody he's converted to a Christian, Muslim, Jew, cannibal. Know what I mean? and it's again, these cases are based on public issues because everybody's presenting that state ID and stuff. Everything is, nobody's asserting their private right if you're handing out a public identification. See, that's one of the mistakes when they pulled me over and I thought I was going to assert my private right of travel, and he asked me for ID and I handed him a driver license, letting him know I wasn't on the clock. Thought I had it all down smooth, but I still handed him a driver license. Like I said, folks, I used to be a fucking fool. I used to be a bitch-ass slave too. And see, Knight dealt with the broad policy discussions, as it said, for employees and employers, not private legal grievances or injustice suffered by the independent being that then has to try to seek redress through his government. and that the petition clause is distinct from the speech clause, of course, obviously. And though the speech clause and expression clause, that freedom of the press and everything, allows me to speak on public issues, it doesn't say that that's the only thing I can speak on and that I have to do it from a public perspective. I can do it from my own private perspective of liberty, of being able to journal everything I see in my public review along my journey. In any form, in any media. And again, if that petition clause doesn't protect your right to bring your own grievance to the government to seek remedy for personal harm, then what means are you left to but to protect yourself at any means necessary by revolting? Now, I'm not condoning this. I'm just saying that this is a natural action. Natural law will take effect sooner or later. And here's the kicker. The petition clause, it predates the broader understanding of free speech. See, in fact, under the English common law and the original colonial governments, the right to petition for redress of personal injury or governmental abuse wasn't a legal right. It was a just liberty. My land was seized unjustly. You go to the king, present your claim, say, this man seized my land unjustly. I'm here to have you restore it. Went to the king. Didn't go to one of his menials. And see, that's a substantive obligation when it comes to them. The leader, the Congress, and the president. It's a substantive obligation. It has nothing to do with politics. The public. And again, I assert if the right is protected and its only function is to initiate a process towards a remedy, such as the petition to redress, then the government must be bound, at least procedurally and in good faith, to be able to engage that process. Otherwise, again, you're making an empty promise. The right is illusory. And it leaves the states to violate rights with impunity so long as you're willing to submit a complaint and they accept it, and that's all they think they got to do. And it's a systemic injustice across all branches. And it pretty much renders the First Amendment's protections non-functional in all cases. And while the courts have upheld the right to file complaints, lawsuits, or petitions, they've avoided imposing a duty on the government to meaningfully respond unless due process is independently triggered. This is the 5th or 14th Amendments. So when they demand an ID, guess what? That triggers the 14th Amendment. When they take property as it relates to that ID, saying you can't have this motor vehicle on the highways because your license is revoked or suspended or whatever, goodness gracious, they just violated both. And it's due to a violation of the First Amendment and the Fourth Amendment, as it both relate to your privacy. They're both substantive rights as it relates to your privacy. The right of the people to be secure in their persons, houses, papers, and effects, so the government doesn't demand the effects, the IDs, so that they can go on their property and take their persons, houses, and effects, automobiles, and things like that, or anywhere else. That's why there's supposed to be a a certain, what do they call it? A brain fart. A grand jury indictment first. Otherwise, they're just running an administrative process that's cycling you through as if though you're one of their slaves. And I'm pretty sure that I could argue that the clause itself implies a quasi due process function. It implies that governmental burden. Not to always agree, but to acknowledge, process, and render a good faith response of something. Even a good faith response in return would be something. Otherwise, it's semantically protected, but functionally abandoned. See, it's not just a liberty to speak about injustice, but a right to initiate redress for personal wrongs. And the public policy cases like Knight don't govern private grievances. And using them to limit the petition clause is a misunderstanding, again, of its original purpose. Substantive obligation logically exists, no matter how you look at it. The right to petition the government for redress of grievances. Therefore, that substantive obligation must exist if the Constitution is to be consistent with its own protections. And I only speak out to restore the substantive dignity. And again, that's why I talked about the diplomatic etiquette earlier. We as people have to learn how to have that substantive dignity in ourselves so we can use that freedom of speech and that freedom of expression in that peaceful assembly to petition the government for redress of grievance, for misidentification, misassociation, the freedom of religion. They shall make no law respecting the establishment of a religion. Well, what about respecting the establishment of oneself? See, I'm arguing this for the soul of every man, just like I'm arguing for the soul of the Constitution. That's what it's missing. The people that have a true soul to stand up and help enforce it with reason and logic and some kind of diplomatic etiquette, stoicism, and sternness. I am so tired of watching people turn into Hitler's willing executioners. It's sad. Let's see what people got to say. I want to thank everybody for joining me. Russ, Bad Barney, Mitch is here. We got JD, Disciple of the Messiah 1, Laura, New Guru. Greetings, everybody. Truth and Empowerment, John Harnick. I think I got everybody so far. Anybody else, feel free to chat. Let me know you're here. Yep, I agree, Mitch. The guys with the better guns are well prepared for rebellion. The people aren't. Yeah, long before the people can get ready for a rebellion, they have to understand a lot more than what they do now. And if you don't understand the First Amendment, you're nowhere near a rebellion. All you can do is point and shoot, literally. Well, yeah, that's what your First Amendment is actually about, your right to make a record. Observe, record, report. That's the thing about that is the record that we make has to be able to portray a good message, whether the elements in it are good or bad. This is why I say when we look back at ourselves, we go to at the end of the day and we look in the mirror and we look at ourselves, we think about ourselves and our actions and our deeds and everything. To go back and look at our mishaps and our mistakes and the things that weren't so good and use them as part of that learning experience, because if you close them out and become shameful of them and try to hide them, you become one of those people that's willing to sit there and accept those little lies about yourself and therefore willing to put out lies on everybody else. You become one of those Hitler's willing executioners. That's how simple it is. If you can't be true to yourself and be the truest to yourself at all times, then you fail. You fall into somebody else's belief system of what you are. You become Toby instead of Kunta. You take upon that name, and you do so gladly as they start slinging ad hominems, making you the character while they play the jester. See, I'm the jester in this. I'm the one that does this stuff to trigger people, politically and emotionally. I hope it's working. I'm hoping it's triggering you to act positively and get off your asses and quit looking so much like Hitler's willing executioners. Because you ain't near as funny as Charlie Chaplin. You run your mouth too much. And with that, I think I'm done. I was thinking I might open the panel, but I think what I'll do is, it's going on 7. I think I might come back at 9. I've got a video on Child Protective Services I want to do a review on. So I think I'll do that at 9. Join me then and we'll open panel. We'll talk more about things and we can talk more about First Amendment there if you want to. In the meantime, you guys know me. I love you, but I don't give a rat's ass whether you love me back. I say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. We'll see everybody next time. Bye now.